Good afternoon, friends. Important video on one of the burning topic. Can we amend or revise GSTR 1? Possible. As per provision, this is permissible by September following the end of particular financial year. And this provision, this September time period is extended to 30th November as per Finance Act 2022, effective from 1st of October 2022. Why somebody would be looking for amending and revising GSTR 1? Important question. We have seen in the past that while furnishing GSTR 1, clerical mistake, which is being done by supplier while filing GSTR 1. So live case example that he has furnished the GSTIN number of, let's say, C instead of GSTIN number of B, to whom actually he has supplied goods or services. Or B2B supply captured as a B2C, hence credit is not reflected in GSTR 2A of the recipient B. In such situation, we are finding scrutiny notices and the discrepancy on credit availed by B in its GSTR 3B, but it is not coming in GSTR 2A. Lot of problem. So what to be done? Time prescribed that if we do any omission or error, it can be corrected by September following the end of financial year, following the end of particular financial year. So one live case study which I am discussing with all of you coming from Jharkhand High Court, important one. Invoice was pertaining to January 2019. And in that particular case, supplier has wrongly furnished GSTIN number of, say, party C as against party B to whom actually he has supplied. So B का GSTIN नंबर डालना था, पर उसने क्या किया? C का GSTIN नंबर डाल दिया. So what happened? This credit is not going to be reflected in GSTR 2A of party B, customer B. So credit was not coming in. So this party B initially has availed the credit, but when it was not coming in a GSTR 2A, he has reversed the credit because it was not coming in GSTR 2A. And he has withheld the amount of GST. And he hasn't paid this amount to the supplier because credit was not coming in its GSTR 2A. So in a given situation, supplier wanted to amend or revise his GSTR 1, but the time period as prescribed, that is gone. September 2019, if I'm talking about financial year 18-19, then it was September following the end of financial year 2018-19. That time period was gone. It only came to know to the supplier's knowledge only when recipient has pinpointed that this credit is not coming in 2A. Hence, I will not pay you this amount. So in 2021, when a recipient found that credit is not coming in and he intimated to the supplier was not in a position to amend or revise his GSTR 1 for the month of invoice raised in January 2019 but shown in March 2019. He could not amend or revise because time period gone. So what happened for the credit which was not coming in GSTR 2A and withheld by the customer? Customer ने वो GST का पैसा रोक लिया. अब क्या होगा? This writ petition has gone to Hon'ble Jharkhand High Court, and very good judgment, I must say that. And this judgment has discussed relevant provision As we all know in a background, when GST got introduced, there was automated GST return system was envisaged. Section 37, GSTR 1, 38, GSTR 2, 39, GSTR 3. Now, having said that, there was provision section 42 and 43 for GST input tax credit matching and mismatching. And what was the process? Supplier will file GSTR 1, which is going to be auto-populated in GSTR 2A of the recipient. Recipient, while filing GSTR 2, can do add, modify and delete. So any transaction which is not coming in, he can take the credit and will finalize GSTR 2 by 15th of next month. Once any add, modify, delete is done by the recipient, it is going to be auto-populated for the supplier in GSTR 1A. And supplier has to either accept or reject while filing his GSTR 3. This was initial system envisaged. We all know that GSTR 2A only came into the picture sometime beginning of 2019, and GSTR 2, 1A and GSTR 3 never got implemented. But ITC matching and mismatching provision 42 and 43 was there for ITC matching and mismatching. If supplier has made mistake, which is being corrected by the recipient while finalizing GSTR 2, then quite obvious, automatically this mistake would have come to the knowledge of supplier had it been GSTR 1A. Had there been GSTR 1A. Since GSTR 2, GSTR 1A, GSTR 3 was not there, and for GSTR 3 we know under section 39 it is now GSTR 3B. So this was the point pleaded before Hon'ble Jharkhand High Court, and it was pleaded by the petitioner, Milord. There is one doctrine of impossibility. Lax non cogit ad impossibilia. For ITC matching and mismatching, there is a provision section 42 and section 43 and corresponding rules under CGST rules. If this automated GST return system got implemented as envisaged, then quite obvious any mistake made by the supplier could have come to the knowledge of supplier because correction is done by the recipient. Supplier ने अगर कोई गलती कर दी, GST नंबर गलत डाल दिया, B2B को B2C दिखा दिया, इंट्रा स्टेट को इंटर स्टेट दिखा दिया और वाइस वर्सा, तो रिसिपिएंट इनको करेक्ट करता GSTR 2 भरते वक्त, और जैसे ही करेक्ट करता GSTR 1A सप्लायर के पास आ जाता और सप्लायर को मालूम पड़ जाती मैंने गलती कर दी है, जिसको वो एक्सेप्ट कर लेता। तो ये ऑटोमेटेड जो ITC मैचिंग मिसमैचिंग का जो डिस्प्यूट था वो खत्म हो जाता। यही GST लॉ में दिया गया था। झारखंड हाई कोर्ट के सामने यही प्लीड किया गया मिलॉर्ड। सेकंड पॉइंट जो ऑनरेबल झारखंड हाई कोर्ट के सामने जो प्लीड किया गया मिलॉर्ड, अब फाइनेंस एक्ट 2022 effective from 1st October 2022, now the government has omitted the section 42 and 43 and 43A, which was introduced by CGST Amendment Act 2018, which was pertaining to ITC matching and mismatching. Omitted. So two-way communication got omitted, but prospectively only from 1st October 2022. So for the past period, 42-43 was existing with the corresponding rules, even 37, 38, 39 only changed as against GSTR 3B was introduced with retrospective date. So it was pleaded before Honorable Jharkhand High Court and stated, Milord, I could have amended my GSTR 1 had the information has auto-populated to me if any correction, add, modify, delete, which is done by the recipient. Since it was not available from the system, it did not come to my knowledge. मुझे मालूम नहीं पड़ा सर कि मैंने जीएसटी नंबर गलत डाल दिया है. अगर जो ऑटोमेटेड जीएसटी रिटर्न सिस्टम था, अगर उसको इंप्लीमेंट किया गया होता तो मुझे ये मिस्टेक जीएसटीआर 1A में मालूम पड़ जाती और मैं एक्सेप्ट कर लेता. चूंकि जीएसटीआर 2 1A जीएसटीआर 3 इंप्लीमेंट नहीं हुआ, तो मैं टाइमली जो सितंबर का टाइम है 2019 फॉर रिलेवेंट केस, मैं अमेंड नहीं कर पाया, रिवाइज नहीं कर पाया. और प्लस रिसिपिएंट ने जो क्रेडिट ली थी उसको उसने रिवर्स कर दिया था. तो मिलॉर्ड, मुझे इस जीएसटीआर 1 को अमेंड करने का, रिवाइज करने का मौका दिया जाए मार्च 2019, जिसमें जनवरी 2019 की इनवॉइस दिखाई गई थी. Hon'ble Jharkhand High Court has held that since it is a revenue neutral case, no loss of revenue to the government, क्योंकि रिसिपिएंट ने उस क्रेडिट को रिवर्स कर दिया था क्योंकि उसके 2A में नहीं आ रहा था. So this supplier must be allowed to amend and revise GSTR 1 because automated GST return system provision was there. 37, 38, 39, 42, 43 along with corresponding rules. दूसरी बात, जो omission हुआ 42, 43, 37 को amend किया गया, 38 substituted हो गया. Corresponding rules जो थे वो सारे के सारे जो omit हुए, सारे omit हुए prospectively from 1st October 2022, meaning thereby the provision which was existing in the GST law was alive. Since it was never introduced, it was not available on portal. So this mistake which could have been corrected could not be corrected because information was not available. Doctrine of impossibility. Hence he should be allowed. And that is what Hon'ble Jharkhand High Court judgment in the case of MAHALAXMI INFRA Contract Limited. Good one, right? Let's listen another part of his Telangana High Court judgment. Contrary now. Similar case. Supplier made mistake and could not correct within the time period for the past period prior to 1st October 2022. He could not correct within the time. Thereby, there was a dispute of credit to be availed by the recipient. Now, question is, after the due date, which is September, following the end of financial year, whether GSTR 1 can be revised and amended. Here, Telangana High Court in the case of YOKOHAMA India Private Limited has said it can't be, and they have relied Bharti Airtel judgment. Bharti Airtel judgment was pertaining to revision of GSTR 3B. In that particular case, Bharti Airtel wanted to revise their GSTR 3B, but Honorable Supreme Court has said if it is being allowed beyond due date, then it may affect the obligation and liabilities of other stakeholders like central and state, and their revenue sharing correspondingly. If it is being allowed beyond due date, after the due date, तो उनकी जो liabilities and obligation है जो central and state आपस में share करते हैं, that is going to be affected. That's the reason Honorable Supreme Court has said GSTR 3B can't be revised. That judgment was relied by Honorable Telangana High Court. In my humble submission, with due regards to both the judgment coming from Jharkhand High Court and Telangana High Court and then Supreme Court. Just because it is going to affect liabilities and obligation of other stakeholders? To my mind, no. In my humble submission, no. As provision was existing 37, 38, 39, 42, 43 and ITC matching and mismatching that and corresponding rules within the GST law. Automated GST return system which was envisaged, since it was not there, Had it been there, supplier could have corrected these wrong particulars, and that too within the time period. Since these information were not available, which was supposed to be as per the law, why he should not be allowed? Honorable Jharkhand High Court judgment is a laudable one, considered all the provision, and the omission which is being done, two-way communication, it is only prospective from 1st October 2022. So omission of 42, 43 and corresponding rules pertaining to ITC matching and mismatching, only prospective. So to my mind, it must be tested again, once again, before Honorable Supreme Court. That is my submission. Of course, way forward, we have to be very careful. Two-way communication gone. Now it is one way. Our credit is dependent on the supplier. And alongside, we have to keep in our mind the corresponding provision for availing credit. You should have tax invoice, receipt of goods and services. Your supplier must have paid taxes. Being recipient, you are regularly filing GST return, and credit must be auto-populated in GSTR 2B. And if it is auto-populated, then it will show that eligible and ineligible. Ineligible can be by way of restriction, and there are 6 restriction under section 38, effective from 1st of October 2022. So we have to be careful. What are those restrictions? Quick. That any supplier who has taken new registration, and if he is invoicing to you for specified period, credit would be denied. Any supplier who default in payment of tax, and you are purchasing from such supplier and that default continues for a specified period, even though आपके 2B में आ रहा होगा, but आपको credit नहीं मिलेगी. Third, if there is a difference in GSTR 1 versus 3B for output tax liability and that exceeds specified amount, credit amount, difference, GSTR 2B versus GSTR 3B, and violating the provision Rule 86B, Section 49, subsection 12 of CGST Act, and any other restriction that may be imposed by the government. So that video is available. You can watch my other video on that credit, how critical and how difficult it would be way forward. With sequential filing of GST return from 1st October 2022, I agree that if any mistake done by the supplier and not auto-populated in GSTR 2B, hence your credit can be denied. But prior to that, we can definitely argue, because these provision was existing, 37, 38, 39, 42, 43 and corresponding rules. And to my mind, that is the legal position. Since it was never introduced by government, now they can't deny. And that is what, just because obligation and liabilities among other stakeholders gets affected, that's the reason GSTR 1 can't be revised. To my mind, we have to look at other aspects as well, with due regards to both the High Court and Honorable Supreme Court judgment in the case of Bharti Airtel. But in my humble submission, I'm sure this matter will go before the Honorable Supreme Court. And I'm sure about, in my humble submission, that yes, this revision must be permissible for the past period. Thanks for watching. Stay tuned. Thank you very much.